Good day, everyone. I would like to thank everyone for taking the time of their busy schedule to come to our event today. And I also would like to thank the speakers for taking the time out of their busy schedule to come here and speak in our event today. Now, the topic of today's event is religion and the law, and how religion or religious laws influence a legal system. And what is religion? Religion is an organized collection of belief systems which are intended to give meaning to life, explain the origin of life and the universe. From the ideas about the cosmos, human nature, religion has formed the basis of society's moral, ethical beliefs, values, and religious laws. Religion has even influenced a preferred lifestyle which many people live by. Also, the word religion is generally used by one's belief, one's faith, and it can be an ideological or theological belief system. Now, what is law? Law, in general, is a system of rules, regulations, or guidelines that people follow in a society and are enforced by a social institution to govern that society. Laws are made by governments, and generally, constitutions are written where people follow them and they preserve the rights for people in a society. And these laws are made through the legislators in general. Now, the formation of law are derived also from the basis of sometimes religious laws, whether ideological or theological. Now, religion and law are both broad topics, and it will take us forever to sit here and discuss how religion influences a legal system in general. So our speakers today will focus on specific issues where religion influences a legal system. And our first speaker I would like to welcome is Justice Joseph Trainor. Please welcome.
Hello, welcome. I would like to address generally, nothing very specific about the law. I would like to address very generally the American experience and the origins of the country. I remember it was about 3 years ago, I was watching a debate for the U.S. Senate. It happened to be in the state of Delaware. And one of the Senate candidates mentioned that in her opinion, she couldn't find where in the Constitution was the principle that there should be a separation of church and state. Now, the debate happened to be at a law school in Delaware. And most of the audience was comprised of law students from the law school. And they all started to laugh in mockery of the senator for having made this observation, and I sat there somewhat shocked. Because the truth is, and hopefully we all know that here, is that there is nothing in our federal Constitution concerning the separation of church and state. And what's more significant is the fact that it can only be understood when you understood what was going on in the country at that time. The phrase separation of church and state came from a letter that Thomas Jefferson sent to the Baptist congregation in Danbury, Connecticut, having to do with the Baptist concern with the way that they had been treated by the Anglicans in a number of states. I mean, the Baptists, quite frankly, were brutalized by the Anglicans, specifically in the state of Virginia, then the colony of Virginia, and that happened as recently to the founding as was a major incident in 1771 that embarrassed Jefferson, that embarrassed Madison, where a Baptist minister was whipped in front of his congregation for doing nothing other than preaching in the state of Virginia. we all know, or we should know, the story of Massachusetts. First of all, the Plymouth colony with the Pilgrims, and the Pilgrims were notoriously intolerant of other people. As a matter of fact, I was taught in school that the Pilgrims came to this country for religious freedom. Nothing could be further from the truth. The Pilgrims left England for religious freedom. They went to Holland, where they had perfect religious freedom. They left Holland, and they wanted to go to a wilderness because their children were being influenced in Holland by the very secular and licentious habits of the Dutch people, and they wanted to go to a part of the world that no one else existed, where they could practice or teach their children and their beliefs without influence by anyone else. Pilgrims were very intolerant of anyone else, but then the Puritans came over and formed the Massachusetts Bay Colony, and where the Pilgrims were intolerant, the Puritans were ruthless. They outlawed, for example, the Quakers. When they heard what the Quakers were doing in other states and all, the first offense for preaching in Massachusetts was having your left ear cut off. Your second offense was having your right ear cut off. Your third offense was having a hot poker put through your tongue. And your fourth offense was being executed. That is just being a Quaker and practicing your religion in Massachusetts. There is to this day a statue out in front of the State House in Boston, a statue of Mary Dyer. She was a Quaker, executed on Boston Common by the Puritans for practicing her faith of being a Quaker. Also, you are probably not aware that the last person hanged as a witch on Boston Common, Goodwife Glover, Goody Glover. There's still a bar and a plaque in Boston commemorating what happened to Goody Glover. Her crime, that Cotton Mather accused her of being possessed by a demon, testified against her before the Great and General Court in Massachusetts. Her crime was only being able to recite the Lord's Prayer in her native language of Irish. And she could recite it in Irish, she could recite it in Latin, she couldn't recite it in English. Therefore, she was possessed by the devil, and she was duly hanged on Boston Common. Now, the country, in every one of the colonies, save three, I think the only colonies that did not have established churches were Pennsylvania with the Quakers, it was New Jersey, Rhode Island, probably the most famous, because Rhode Island was the first of the colonies to give genuinely religious freedom, religious liberty to all sects. All other colonies at the time, long before the founding, 150 years before the founding, all had established churches. They were state established. And what that means is that everyone who lived in the colony had to pay taxes to the church. This was not discretionary. This was a tithe that was enforced by the political leaders of the colony. If you lived in Massachusetts, you paid taxes to the Congregational Church. If you lived in New Hampshire, you paid taxes to the Congregational Church. If you lived in the state of Virginia, you paid taxes to the Anglican Church. Now, this was to the exclusion of all the other religions in the country at the time. And it wasn't just, if, for example, in Virginia, the problem with the Anglicans and the Baptists, because a lot of these animosities and a lot of these sectarian issues carried over from the old country. And in the people that settled our southern states, the Carolinas, Georgia and all, many of them, and by the way, that the founders were very, very aware of, many of these people were responsible for our United States winning the Revolutionary War when the English General Howe recklessly decided to engage in a southern campaign. He ran against all these Scots-Irish Presbyterian backwoodsmen who kicked his butt all over the Carolinas and Georgia, and eventually made him retreat to the ocean, where the blockade prevented him from being reinforced, and the English had to surrender. It was primarily the Scots Presbyterians in that campaign, the Scots-Irish Presbyterians. they were no fan of the Anglicans because the Anglicans were their biggest nemesis back in the old country and in Scotland and in Northern Ireland. Similarly, in the Massachusetts and New Hampshire area, the Congregationalists, the Puritans, were brutal on the Quakers, the Baptists, the Catholics, the Jews. So, at the instant of our founding, when we created a national government, all the Constitution said was, number one, in Article 6, was that there was no requirement that you had to take a religious oath of office. And as a matter of fact, what most people don't understand, the Constitution only requires that you take an oath or an affirmation. And the only reason that the word affirmation is in there is that Quakers can't take oaths, but they can affirm. And so in respect to the Quakers, we put in the Constitution an oath or an affirmation. But as to the rest of the country, what everyone unanimously did not want to see established was one national church. When we created our federal Constitution, at the time of the creation, in all the states that had established state churches, they remained. And as a matter of fact, in Massachusetts, our established state church, the Congregational Church, that is the taxing power of the church against every citizen in Massachusetts, existed in Massachusetts until 1833. And as a matter of fact, there was a provision in the Constitution that allowed that a similar provision existed in our state constitution until just 3 years ago. That was exercised from the Constitution in the year 2010. So the anti-establishment clause in our federal Constitution was only to the fact that that none of the states wanted the federal government to be able to establish a national church. The free exercise of religion clause was clearly that as a corollary to the Establishment Clause, they didn't want the federal government interfering with the free exercise of religion, by the way, including the establishment of state churches on the state level. They didn't want the federal government interfering with the establishment of state churches on the state level. And that's why when the 14th Amendment came around in 1868 and it directly applied the First Amendment to the states through the 14th Amendment, the First Amendment and the Bill of Rights to the states, it's a little incongruous the way the Supreme Court has interpreted the Establishment Clause, because they completely ignore the other clause in the same provision of the First Amendment, which is to say that the state should not interfere with the free exercise of religion. And interestingly, even though the 14th Amendment was created in 1868, the first time that the Supreme Court even waded into these waters was not until 1947. And since then, there has been a number of conflicting opinions. Quite frankly, they just can't get their act straight on this. Now, part of the reason that the states, at the time of the founding, most of the states, there were just a couple of exceptions. Connecticut did not disestablish. Massachusetts did not disestablish, as I said, until 1833. As a matter of fact, when John Adams was campaigning for the adoption of our state constitution, which he drafted in just before 1780, Adams was campaigning for the requirement that there be religious schools created in every county in the Commonwealth of Massachusetts, and that they be publicly funded. And the reason he said in these debates in our state constitutional convention in 1779 was that a democratic people cannot exist without a strong attachment to a religion. This is interesting because in 1748, Charles Baron Montesquieu published his famous treatise on the laws in 1748. In the treatise on the laws, Montesquieu pointed out that there were three kinds of government conceivable in the entire history of human history. First was monarchy. And he associated the creation of governments with the kind of disposition of the people that was required for that form of government to be successful. So in a monarchy, Montesquieu pointed out to everyone that the kind of disposition that was necessary was that the people had to be honorable. They had to respect honor. The second kind that he pointed out was a tyranny. And the disposition required of the people in a tyranny was very simple: fear. They had to fear the tyrant. And this is something that then the tyrant will cultivate. And if you look at any tyrant of the 19th, or 20th, 21st century, you'll see that that's the first thing that a tyrant does. This is all what Montesquieu pointed out in 1748. The third kind was a democratic republic. And through Montesquieu's study of John Locke, the Bible, Cicero, Aristotle, Montesquieu pointed out that a democratic republic can only exist if its people love virtue. The citizenship of a democratic republic have to be virtuous. Our founding fathers understood this profoundly, which, by the way, and I don't know if this is generally understood, it's not very well taught in school. At the time of our founding, there was a debate in Parliament. This is as to how the British Parliament would react to the colonists on this side of the Atlantic. And the debate in Parliament was basically that these are the English lords and aristocrats and the educated Englishmen, and they were making fun of the Americans as Hicks farmers, frontiersmen, the uneducated colonists on this side of the Atlantic. And Edmund Burke got up, and he pointed out to the Parliament that there were more books sold and read in the American colonies up till that time in the 18th century. More books, there were more than twice the number of books sold in the American colonies on a per capita basis than all of England. And Edmund Burke pointed out to the members of Parliament that the American founders were much better educated, that the general citizenry of this country was much better educated. So when I say that Montesquieu published his Treatise of the Laws in 1748, almost certainly every American founder read them, and we know that because we have Jefferson's library, we have Adams's library. It's interesting that all of Jefferson's books are brand new. They form the original collection of the Library of Congress. The bindings weren't even broke. Adams' library, however, every book in Adams's library was dog-eared, annotations written in the margins and all. He had certainly read Montesquieu. The point is that as Adams points out, is Adams said specifically, our Constitution was made only for a moral and religious people. It is wholly inadequate for the government of any other. So what the founders did is that in preserving the influence and religion in the states, and they understood, quite frankly, that in saying that democratic republic, the prominent disposition required of the people is virtue. They also understood that this was influenced by an understanding of the natural law that assumes that human beings are rational creatures, that you are therefore fit for a rule of law. And if you're fit for the rule of law, and if a requirement is that you have to be virtuous to rule yourself, the only way that you can achieve virtue within an understanding of the natural law is if you're totally free. Now, Montesquieu pointed out at the time that there are two competing versions of freedom historically, both of which Montesquieu said are very misleading. One is that democracy is the equivalent of freedom and liberty. Montesquieu said that is completely wrong. The Greeks made that mistake, and you saw what happened to the Greek Republic, is that to be free is to be free is not necessarily I'm misstating that. To be able to do whatever you want in a democracy is not the equivalent of being free and virtuous. Montesquieu also said that a misunderstanding of freedom is that never confuse freedom with the ability to be licentious. Is that freedom is the ability to make the correct choices. It's not an encouragement to make the wrong choices, because he said that a licentious society will begin being free and will quickly lose its freedom, so it's a contradiction in terms. That the only way that you can maintain a free society is through a virtuous society. So at our founding, the founders had a profound understanding that the only way that we were going to keep our virtue and therefore our freedom and keep our republic is if we maintain our people being a free and religious people. That's it.
I think we can do more than that. That was good. Thank you, Justice Trainor. The order of events is that we shall have all the speakers speak, and then after we will take questions and answers. So please welcome Professor Martin.
Thank you. I'm more comfortable speaking when I stand up, so I'm going to do that. When we first discussed this program, I had the poor judgment to mention to Ali that I was aware of a historical sequence of events whereby Christianity influenced the development of equity jurisprudence, and he came back and asked me to talk on that subject. I need to define two terms, namely one Christianity and the other equity jurisprudence. We have to go back to the 11th century for our definitions of both. In the year 1054, the Christian church formally divided itself between the Eastern Church, which came to be known as the Orthodox Church, and the Western Church, which came to be known as the Catholic Church. In the fullness of time, the Orthodox Church has mostly evolved upon national lines, the Greek Orthodox Church, Russian Orthodox Church, Armenian Orthodox Church, and so forth. But in the West, the Catholic Church, and you can spell Catholic with a small c, in which case it just means universal, or a big C, which means the Roman Catholic Church, remained the universal church of the West. And in support of its claim to be universal, it had two big things going for it. One was the supremacy of the pontiff and the curia at Rome in all things religious, and in many matters of civil society as well, because much conduct not punishable as criminal was regarded as sinful by the church and was punished by the church in the form of penance and, in extreme cases, excommunication. For example, the prohibition against usury. Usury was sinful. It was not prohibited by the common law, would not result in a prosecution, but the church attempted to prohibit it. And in medieval times, there was no separation of church and state, so the church as well as the state fixed norms for human behavior. So when I talk about the influence of Christianity on the development of English equity, I am talking about the what we now call the Roman Catholic Church, which was then, of course, the universal church of the West. The other thing that the church had going for it was the Latin language. It was universal, and not just for theologians, but for all learned people, all learned men, including lawyers and judges. Incidentally, does anybody know when the College of Cardinals elected Francis as a pope, did they conduct their business in Latin? If they didn't, they would have needed an army of interpreters comparable to the General Assembly of the United Nations. What language would they conduct their business in? I don't know. I do know that at Vatican II, the much beloved Archbishop of Boston, Richard Cardinal Cushing, referred to himself and his colleagues in the American cardinals as the Church of Silence, because their Latin was so bad that they couldn't make themselves understood. So whatever vernacular language scholars, theologians, lawyers, and judges spoke, they all, learned people, could read and understand and write Latin. Best example, perhaps, the great medieval theologian and scholar Thomas Aquinas, who was born in Sicily and undoubtedly spoke some Sicilian dialect incomprehensible even to other Italians, let alone to people of other countries. But because he wrote in Latin, people all over the Western world read him. Okay, the other term I want to define is equity jurisprudence. Once again, we go back to the 11th century and the Norman conquest, which was accompanied or followed by an aggressive centralizing of government under the Norman kings and the rapid growth of the common law. Within 150 years, the three kings' courts were well established: the King's Bench, the Common Pleas, and the Exchequer. Judges, royal judges, had been appointed and commissioned. They traveled throughout the country, presiding at trials. They met collegially back in London in what became the origin of collegial activity on appeals. And the procedures were well established. Procedures of these courts were well established by the end of the 12th century, the reign of Henry II. Procedure in the common law courts was to purchase a writ from the king issued by the chancellor. And the writ authorized and directed the court to hear and decide the case being pleaded by the plaintiff and award an appropriate remedy if the court found for the plaintiff. In 1258, there was a revolt among the barons who forced Henry III to agree that the chancellor should not invent new writs. That led to fossilization of the writ system and three major inadequacies in the remedies available in the courts of law. No suit number one, no suit to compel the performance of a contractual obligation would be entertained before damage had been caused. The only remedy available was an award of money damages for the loss caused by the breach of contract. Number two, no suit to prevent a threatened injury to property would be entertained. Instead, the injured party was limited to an award of money damages for the injury after it was completed. And number three, all contracts were construed exactly as written. No correction of the language of a contract or other instrument was allowed, no matter how compelling the evidence that the written expression of the parties' agreement was erroneous. This, what has been called fossilization of the writ system, led to a need for relief in exceptional cases. And that relief was an appeal to the king. Now, the king was the fountain of justice, both in his common law courts and in his persons, and thousands of the petitions for relief addressed to the king remain in the archives of the Public Record Office in Britain, urging the king to consult his conscience and grant relief for the love of God and in the way of charity. And you notice the king is asked to consult his conscience, not his precedents. The great English historian Frederick William Maitland, publishing in 1895, described the appeal to the chancellor this way: very often the petitioner requires some relief at the expense of some other person. He complains that for some reason or another, he cannot get a remedy in the ordinary course of justice, and yet he is entitled to a remedy. He is poor, he is old, he is sick, his adversary is rich and powerful, will bribe or intimidate jurors, or has by some trick or some accident acquired an advantage of which the ordinary courts, with their formal procedures, will not deprive him. The petition is often couched in piteous terms. The king is asked to find a remedy for the love of God and in the way of charity. Such petitions are referred by the king to the chancellor. The king had two great bureaucracies over which he presided, civilian bureaucracies, excluding, not to speak of the military. The exchequer, which was the bureaucracy concerned with the king's revenues, and the chancery, which was the king's secretariat. And the chancellor, the head of the chancery, was almost exclusively in those days a cleric, often a bishop or an archbishop. Gradually, in the course, again reading from Maitland, gradually in the course of the 14th century, petitioners, instead of going to the king, will go straight to the chancellor, will address their complaints to him, and adjure him to do what is right for the love of God and in the way of charity. Now, the one thing that the chancellor may do in such a case is to invent a new writ, and so provide the complainant a means of bringing an action in a court of law. But in the 14th century, the courts of law have become very conservative and are given to quashing writs which differ in material points from those already in use. But another thing that the chancellor can do is send for the plaintiff's adversary and examine him concerning the charge that has been made against him. Gradually, a procedure is established. The chancellor, having considered the petition, or bill as it is called, orders the adversary to come before him and answer the complaint. The writ whereby he does this is called a subpoena, because it orders the man to appear upon pain of forfeiting a sum of money. It is very different from the old writs, whereby actions are begun in the courts of law. They tell the defendant what is the cause of action against him. He is to answer why he assaulted and beat the plaintiff, why he trespassed on the plaintiff language, why he detains a chattel which belongs to the plaintiff. The subpoena, on the other hand, will tell him merely that he has got to come before the chancellor and answer complaints made against him by another. Then when he comes before the chancellor, he will have to answer on oath and sentence by sentence the bill of the plaintiff. The procedure is rather like that of the ecclesiastical courts and the canon law than like that of our old English courts of law. Well, what is the chancellor to consult when a remedy is sought? To us, 21st century lawyers and students of law, the answer to this question is precedents. But to the medieval chancellor, the answer to that question was conscience. And equity has sometimes been described as a court of conscience. What would the chancellor's conscience tell him? The answer lies in the Christian concept of natural law, which I'm glad Justice Trainor adverted. Okay, I am not a Roman Catholic. I've been okay so far on English legal history, but when we get into medieval Catholic theology, I am out of my water, and I urge any of you to correct me if I fall into error. Again, we go back to the 11th century and the rediscovery of Roman law. Roman law was universal in the Roman Empire. The rediscovery of Justinian's institutes fostered vigorous scholarship about the law of Rome, centered on the University of Bologna in Italy, which was founded in 1088, but dispersed among other centers of learning in Europe. Since the fall of Rome, there had been no universal law. And the medieval scholars were attracted to this universality of Roman law. And the Romans referred to lex naturae, the law of nature. And Christian theologians connected a universal law of nature to the Christian monotheistic God. The law of nature then was thought of as the law of God. And this is the origin of the term natural law in the teachings of the Catholic Church. God is perfect. Therefore, the law of God must be perfect. Human beings cannot perfectly know the law of God because human beings are imperfect. However, human beings can approach that knowledge through reason. Reason being God's gift to the human species. Theologians disputed whether reason alone would enable one to approach knowledge of God's law, or whether reason plus revelation was required. And I don't express any opinion on that subject. So the chancellor should ask himself, what does the law of God direct or compel me to do in this case? And remember, the medieval chancellor was almost always a cleric, usually a bishop or archbishop, to whom sophisticated theological thinking would have been a way of life. So how do you find the law of God? Not in books, not in precedents, but in your conscience. The purpose of the law of God is to do justice. Martin Mayer wrote a book, American journalist Martin Mayer wrote a book quite a few years ago called The Lawyers, which he defined justice as the visceral reaction of well-informed persons. And I think that's a pretty good definition. First, inform yourself, for the chancellor. First, inform yourself well. Second, pray to God for guidance. And then act on your visceral understanding. I used to teach a course called Restitution, which is devoted to the prevention and remediation of unjust enrichment through quasi-contracts and constructive trust. You've all encountered quasi-contracts, right? In order to talk about the prevention of unjust enrichment, you've got to have an idea of what you mean by unjust. And often it's easier to recognize injustice than it is to recognize justice. And the chancellor should act to prevent injustice if possible, or to mitigate injustice if prevention is impossible. And I just want to stick to two topics now, namely contracts and trusts, to discuss what the chancellor could do. Where the common law could only grant money damages for breach of contract and insisted upon interpreting contracts exactly as written, the chancellor could grant specific performance of a contract as opposed to just damages for breach. The chancellor could also deny specific performance if the original bargain was unconscionable. The chancellor could relieve from penalties and forfeitures. If, for example, you enter into a contract to build a barn, $25,000 to be finished by July 1st, with a provision that a $5,000 penalty will be assessed if the barn is not ready by July 1st. And as it happens, the barn is not ready till July 3rd. The actual breach of contract damages are minuscule, but nevertheless, according to the strict terms of the contract, you owe a penalty of $5,000. Equity could enjoin a party from enforcing an unconscionable penalty or other term of a contract that was deemed unconscionable. Equity, the chancellor could prevent unjust enrichment by imposing contractual duties, even when there was not a contract that could be enforced in the courts at common law, what we now would call a quasi-contract. Equity could grant rescission of a contract if, for example, the contract was entered into under the influence of fraud, misrepresentation, or mistake. The chancellor could grant reformation of a contract if the written instrument did not conform to the parties' actual agreement. And in all of these, the application of all of these remedies, of course, the chancellor was to take into account all of the facts and circumstances of the case, even facts and circumstances which would not be admissible as evidence in a court of common law. Well, okay, what could the chancellor do in connection with trusts? This needs to be understood, by the way, in the context of turf wars between the common law courts and the court of the chancery, which were so much a feature of the early in history, and especially in the Tudor and Stuart eras in England, where each sought to maximize its authority at the expense of the other. Again, Maitland summarizes some of the history of these turf wars. In this period, one of the commonest of all the reasons that complainants will give for coming to the Chancery is that they are poor, while their adversaries are rich and influential, too rich, too influential, to be left to the clumsy processes of the old courts and the verdicts of juries. However, says Maitland with a touch of irony, this sort of thing cannot well be permitted. The law courts will not have it, and Parliament will not have it. Complaints against this extraordinary justice grew loud in the 14th century. In history and in principle, it is closely connected with another kind of extraordinary justice, which is yet more objectionable, the extraordinary justice that is done in criminal cases by the King's Council. Parliament at one time would gladly be rid of both the Council's interference in criminal matters and the Chancellor's interference in civil matters. And so the Chancellor is warned off the field of common law. He is not to hear cases which might go to the ordinary courts. He is not to make himself a judge of torts and contracts, of property or land and goods. But just then at this time, it is becoming plain that the Chancellor is doing some convenient and useful works that could not be done, or could not easily be done, by courts of common law. He is taken to enforcing uses or trusts of the no doubt, they were troublesome things that might be used for fraudulent purposes, and statutes were passed against those who employed them for the purpose of cheating their creditors or evading the law of mortmain. But I have not a doubt that they were very popular, and I think we may say that had there been no chancery, the old courts would have discovered some method of enforcing fiduciary obligations. That method, however, must have been a clumsy one. A system of law which will never compel, which will never even allow a defendant to give evidence, a system which sends every question of fact to a jury, is not competent to deal adequately with fiduciary relationships. On the other hand, the Chancellor had a procedure which was very well adapted to this end. To this we may add the very possibly the ecclesiastical courts had for a long time past been punishing breaches of trust by spiritual censures, by penance and excommunication. And so by general consent we may say the Chancellor was allowed to enforce uses, trusts, or confidences. Thus one great field of substantive law fell into his hand, a fruitful field, for in the course of the 15th century, uses became extremely popular. And then there were some other matters that were considered to be fairly within his jurisdiction. An old rhyme allows him fraud, quote, fraud, accident, and breach of confidence, unquote. There were many frauds, which the stiff old procedure of the courts of law could not adequately meet. And, quote, accident, unquote, in particular the accidental loss of a document, was a proper occasion for the Chancellor's interference. No one could set any very strict limits to his power, but the best hint as to his extent it could be given in the 16th century in the words, quote, fraud, accident, and breach of confidence, unquote. What uses refers to what we now call trusts. Just to give you an illustration of how the enforcement of a use could ameliorate the state of a married woman. Suppose you are the father of a daughter who is to be married, and you do not completely trust the guy that she's marrying, and you know that if you want to see that your daughter is protected against his excesses, and in particular protected against his creditors. If you give money to your daughter upon marriage, he is the person in charge of the family's money. Incidentally, the old saying that a woman was nothing more than a chattel to her husband in marriage at common law is a gross misstatement of the law. For one thing, a characteristic of the ownership of a chattel is you can sell it, and there never has been a time in Anglo-American legal history when you could sell your wife, legally anyhow. But if you gave that money to somebody else that you trust, such as your son, for the use of your daughter, then he owned the legal title to the money, and it did not pass to her husband. And on the other hand, if your son proved unfaithful to applying that money for the use of your daughter, the chancellor would restrain him or penalize him by requiring him to reimburse the fund that from which he had wrongfully diverted money. It's just one example of how the Chancery invented remedies for really to protect people against hardships imposed upon them by the common law. Many of these remedies are words that you now know as a result of being in law school. You know about injunctions, you know about rescission, you know about reformation, you know about something about trust, and so forth. And they have stayed in our law, even though equity as a separate compartment of the law has almost been abolished, has been amalgamated, both in the federal system and in almost all American states, and in England, into a single system of jurisprudence. The idea that conscience can dictate discretionary remedies is still a part of our law, and it does go back to the Christian medieval concept of the natural law, which the Chancellor should seek and apply. Thank you very much. It's been a pleasure talking to you.
Thank you, Professor Martin. Professor Martin is one of our faculty advisors. He's always there to support us. Thank you for coming today, Professor Martin. Our next speaker is an international law scholar, and he's also a professor here at Mass School of Law. Please welcome Professor Forrest.
Thank you. Well, I have about 20 minutes to discuss approximately 5,000 years of the influence of religion on international law. And in the research that I did in preparing my remarks for today, I found out some things that actually surprised me. And one of them is, and some of this came from the International Law Society, which is located in Washington, D.C., and that in the 20th century alone, over 200 million people were killed as a result of religious antagonisms. That's 200 million people just in the 20th century. How many have been killed during the 20 centuries prior to the 20th century? So it's fair to say that religion has had a major influence on the development of international law. Most of the early disputes rose amongst tribes and other societies before the organization of formal nations as we know them today, and most of the people involved in these societies would ask their gods, God of heaven, the God of earth, the God of the stars, for assistance in resolving their disputes. But the ancient Greeks had what they thought was a foolproof way of resolving disputes, both amongst themselves and those from neighboring countries. Does anybody know who Pythia was? Those of you in my international law class should know. We have an exam coming up. Pythia was the goddess of Mount Parnassus, and legend has it that she would take her cues from the god Apollo. And the way she would take these cues was, according to Plutarch, who actually recorded some of this, and who at one time was himself a high priest on Mount Parnassus, was she would read the vapors coming from fissures that existed under the temple of Apollo. And the vapors, according to Plutarch, would tell Pythia what the decision should be on any particular matter that was brought to her. And the supplicants who came to Pythia were encouraged to bring gifts. And of course, the bigger the gift, the better the decisions that Pythia would make. One of the problems that developed with Pythia was that she was chosen for this function based on youth and beauty. And youth and beauty became too much of a temptation for some of the high priests. So they changed the rules. And at one point, the requirement in order to be Pythia was that you had to be, again, according to Plutarch, an elderly woman of at least 50 years of age. So I guess at that time, if you were 50 years of age and a woman, you were considered to be elderly. This process actually began in about 400 BC, and it lasted until about 1600 AD, almost 2,000 years that Pythia was used by the Greeks for resolving disputes. And what happened was the later-day geologists who read Plutarch wanted to know, well, what was this process? How did Pythia actually know how to make a decision? And it turns out that there were, in fact, springs underneath the temple of Apollo, and those springs were heated by the movement of tectonic plates under the temple, and they released gases. And one of the gases that later geologists found was a gas called ethylene. And ethylene actually produces a trance-like state if you ingest too much of it. And so the latter-day geologists have determined that Pythia was actually in some kind of a trance as a result of breathing these ethylene fumes. After a few centuries, until about 1400, the oracle actually ran out of gas, and Pythia was no longer necessary. As the world grew larger, new societies formed, empires formed, nations came into being, cultures developed, languages developed, beliefs developed, and Christianity became dominant. And these entities had to coexist, so trade developed and disputes occurred. And gradually, a concept that we know today as the law of nations developed, originally known as the higher law or the law of nature, and that has matured into this concept today as the law of nations. And during this formative period, wars were common. 30 Years' War, the 100 Years' War, the 80 Years' War, the war for this, the war for that. And these wars continued up through the middle of the 15th century when Hugo Grotius was born, who actually is known today as the father of international law. He wrote a 3-volume work called The Law of War and Peace, heavily influenced by Christianity, especially the Old and New Testament. And he died in 1645, and about 3 years later, we had the Treaty of Westphalia, which ended the 80 Years' War, the 30 Years' War, and the 100 Years' War. And that was the beginning of what we know today as modern international law. But the problem was that it was based on Christian principles, and the Islamic writers of the time were quick to argue that Islam has much to offer to international law by way of the reasons international law has developed. And so these Islamic writers challenged this European Christian underpinnings of international law, and international law then began to develop around three theories. The first was a separationist theory, similar to the system that we have in the United States with the separation of church and state, as Justice Trainor discussed earlier. And then there was an accommodation theory, recognizing that religion has an important role to play in international law. And a well-known justice who sat on the International Court of Justice many years ago, he's since retired, he's about 88 years old now, Justice Christopher Weiremantry. He put it this way in an article he wrote in 2004. Given the strength in the modern world of religious traditions such as the Buddhist, Christian, Hindu, and Islamic, that they command the allegiance of over 3 billion of the world's population, there cannot be any doubt that future thinking on international law can benefit deeply from the teachings contained in these traditions. And then there was the double-edged theory of international law, that religion is like a double-edged sword. It can be used positively or negatively. And all great religions have at least two what we would call broad tendencies in their traditions. One is to be universalistic. Professor Martin referred to this concept a short moment ago, and accept those who hold other beliefs. And the other is to be exclusive and claim that there is only one path to salvation. And the last theory seems to emphasize the first over the second, but in developing nations today, it's impossible to categorize religion into these boxes. The dichotomy between these different concepts is magnified by the current jurisprudence of the European Court of Human Rights, which sanctions, for example, the wearing of headscarves by Muslim women in public places, and the general view of the court that democracy and human rights cannot exist within a system based on Islamic Sharia. And the problem is really impossible to overcome in Muslim states whose constitution formally recognizes Islam as state religion and Islamic law as part of domestic law. Much like we have in this country, where the United States Supreme Court has ruled that international law is part of our law. Does anyone know when the United States Supreme Court made that determination, that international law is part of our law? Students from international law? It was over 100 years ago, in 1900, in the Paquette Habana case, that the United States Supreme Court decided that international law is part of the domestic law of this country. Let's turn to the UN for a moment. Woodrow Wilson had a good idea back around 1920, when he came up with the idea of forming some kind of an organization to deal with international disputes and international agreements. And in 1945, the United Nations was formed, and at one point, the General Assembly adopted what's called the Declaration of Human Rights. Article 18 of that declaration states as follows: everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion, and they use the word his, meaning it covers both male and female, has the right to change his religion or beliefs. Change his religion or beliefs. making a distinction between religion and a belief. And freedom, either alone or in community with others, in public or private, to manifest his religion or belief in teaching, practice, worship, and observance. This means, under international law, belief in religion is something that one can change. In other words, you can give up a religion for a belief. You can give up a belief for a religion. So you might ask, how is this possible for a Muslim person who has no right under Sharia to abandon Islam? But to even ask this question maybe shows a misunderstanding of what the word religion means as the UN adopted it in the Declaration. Because Muslims tend to use the word religion to mean true devotion to God. And for many Muslims, religious freedom means the freedom to embrace what is true. It does not mean to turn away from the truth. So you might say, what does this have to do with international law? Well, the loose connection is that under Islamic law, agreements and contracts must be fulfilled in good faith. The Quran says that you must be faithful to your pledge when you enter into a pact. And there is a concept in international law known as pacta sunt servanda. Students from international law, I'm sure, remember that, or should remember it, coming up. And that loosely translated means agreements must be observed. So that's a concept in international law that the international community recognizes and that Islamic law also recognizes. Let's turn to a current situation that's beginning on the Korean Peninsula, the threat of nuclear war. Judge Weiramentry was an outspoken critic of the proliferation of nuclear weapons, and here's what he had to say about a case that he actually sat on when he was on the World Court. It was a dissenting opinion, but his comments are relevant. He said, it greatly strengthens the concept of humanitarian laws of war to note that this is not a recent invention, nor the product of any one culture. The concept is of ancient origin, with a lineage stretching back at least 3 millennia. It is deep-rooted in many cultures: Hindu, Buddhist, Chinese, Christian, Islamic, and traditional African. These cultures have all given expression to a variety of limitations on the extent to which any means can be used for the purposes of fighting one's enemy. The problem under consideration, he noted, is a universal problem. The multicultural traditions that exist on these matters cannot be ignored. The judge then went on to analyze the relevant provisions of those religions that he referred to for his opinion that, and this was the gist of his dissenting opinion, the threat of the use of nuclear weapons must be seen as illegal in all circumstances under international law. So these cases and references that we've just discussed by various courts and international tribunals shows that maybe religion may not serve directly as a normative source of obligation under international law, but it can serve as a valid complementary means of establishing customary international law, or at least of establishing state practice in relevant cases. So we can conclude that the relationship between religion and international law is double-edged. It can be either amicable or adversarial, depending on what we, the human agents of it, want it to be. And as our world becomes smaller and nation states and people become more interdependent on one another, international law becomes more and more relevant. And the fact that strong religious convictions exist throughout the world means that religion will continue to have a significant impact on international law. Most of these religions that we've talked about recognizes that God created man. And in the United States, we're told that Samuel Colt made them equal. Thank you.